Welcome back to the morning show here on Arise News. I am Oji Akbe.
And I'm Rufai Hosseini.
The Consumer Protection Council, CPC, is the apex consumer protection agency in Nigeria. The council, in fulfillment of its statutory mandate, deploys several regulatory tools to monitor and modify behavior of service providers and manufacturers. But the challenges that have befallen the Nigerian consumers are enormous. From epileptic services to bad quality product, it looks as though the Nigerian consumer is in dire straits. So joining us to shed more light on this is Babatunde Irukera, Director General and Chief Executive Officer, Consumer Protection Council. Good morning, sir, and welcome to the morning show.
Good morning.
All right.
Thank you for joining us. So as you heard in my introduction, I guess my first question is, how much consumer complaints do you get in your council, and how has the council dealt with these consumer complaints?
Thank you, but I'd like to correct something. Actually, earlier on this year, a new law was signed, and so the Consumer Protection Council became the Federal Competition and Consumer Protection Commission, and still does, for the most part, the same type of work, consumer protection, but it also adds a new dimension, which is competition regulation. And so to your question about how many complaints we receive, approximately we're doing about 989 complaints on a weekly basis now.
Wow, that's a lot of complaints. And how have you been dealing with these complaints?
Well, we approach these complaints from multiple dimensions. Typically, the vast majority of the complaints are simple issues between a purchaser and a supplier or a retailer. And so those ones usually resolve very quickly in the sense that we get the supplier or the retailer involved and some kind of a middle ground or some kind of a amelioration occurs. Now, some others are far more complex when there's a dispute and a retailer or supplier challenges or refutes the allegations of the consumer. Others are more industry-wide problems, and we see a lot of that in electricity, telecommunications, aviation, and certainly banking. And so while we resolve complaints on a daily basis, we're looking to maximize all the tools that we have in the council and with the other regulators in that space to address what seems to be a serious pattern across the board.
Right, so first I'd like to apologize for, those skirmishes that heralded bringing you here, but you're finally here now, and I'm excited you talked about the competition part. The competition part is still really, really, not elaborately talked about in this country. And when you look at other climes, take for instance America, we've had like a Shaman Act since the 1800s here, and businesses still face a lot of competition in terms of pricing. We saw that indicative recently when a ride-hailing company came into the market, and the other company that was prevalent in the market then was pushed out because of unfair price. I mean, what are you doing as regards this? Can you walk us through the body of the law that has to do with competition and antitrust in this country?
Well, yes, and you actually have demonstrated your knowledge of the history of antitrust regulation, and you're right. It started with the Sherman Act. It was then an extremely ambitious effort in the United States, and since then, the United States has become one of the most robust business environments from an antitrust or competition regulation standpoint. And Nigeria is just getting on the cusp. We're late in arriving at the party, but it's still the right time to arrive. In some sense, there were competition provisions in the different pieces of legislation, whether it's the civil aviation regulations, certainly in the electricity regulatory environment under the Communications Act, we also had. But having a robust, clear, and comprehensive or integrated framework for regulating the markets for anti-competitive conduct didn't start until we had this new law, which was promulgated in January. And what the law prohibits are, the usual anti-competitive conduct. The biggest thing that we're looking to do starting out is to address entry barriers, because we subscribe to the philosophy that if you allow other competitors to enter and thrive in the market. It would certainly promote competition, which would promote innovation, fair pricing, certainly choices. So in addition to eliminating entry barriers, which we intend to do by looking at all kinds of restrictive covenants and mutual exclusive understandings that prevent others from being able to take advantage of the market apparatus, we would also be looking at those who abuse their dominant position. Dominance in competition parlance is not necessarily a bad thing, but abuse of dominant power certainly is prohibited under the law. And then there would also be monopolies who act in an inappropriate manner that impedes competition or distorts the market. All of that will come under some kind of regulatory scrutiny and oversight, and including, of course, mergers. You would probably look at two companies merging in the same market to see if it would impede the market. There is also established by the law a Competition and Consumer Protection Tribunal, and so decisions of the regulator can be subjected to some kind of a judicial process.
All right. Okay. I just wanted to follow up on that real quickly. Thanks so much, OJ. When you talked about mergers, that's a part I'm really very excited about. And that's a part I'm really excited about because the competition laws are coming into play. Only recently, we saw the case of Deutsche Bank in Germany that wanted to merge with another bank, but they said it was going to be too big. We've had cases where some banks or some companies have taken on many other companies, and all of a sudden, we've sort of had corporate behemoths overnight because of the merger sector in this country. I mean, when this law comes into place, what would you do differently as regards that vis-a-vis the other interest that ensues? Because this merges as a result of big interests.
Well, I mean, you're entirely correct, but interests are things that evolve and develop and are still subject to law. And the way the process would work is that for two intending companies, the statute provides some level of clarity, but expects the regulator to also provide additional clarity by setting guidelines and thresholds. And so there would be what you call a small merger, which is usually where the numbers, the turnover is not large. Then you have what you call the medium mergers, and then you have a large merger. And so what would have to happen is, at least with the medium and the large mergers, you've got to notify the competition authority about the impending merger. And so there would be some kind of a market assessment or analysis to determine whether that merger would significantly impede competition or eliminate or diminish competition. And if it will, if it won't, obviously, then the merger would be allowed. If it will, there are a few options at that point. You can resist the merger, in which case the merger would not occur, or you can modify certain elements or behavior in the market. For instance, in airline mergers, you might be asked to give up certain frequencies, and sometimes you might be asked to open up certain businesses. For instance, a company that also owns an ancillary operation that is part of the supply chain for the operations of that industry might be asked to open that up to other competitors. So there are many things you might do to either approve a merger, or when it's absolutely impracticable for the market to operate fairly in the presence of that merger, then you disapprove the merger.
Okay, well, what are other regulations that you have? I believe that you also have some sort of regulation with the banks as well, speaking of banks, that you have a stoppage of bank charges. Is that part of the regulations that you have in your council?
Absolutely. Well, and with respect to bank charges, there are two sides to that. There's a consumer protection component of that, in the sense that some of the largest in number complaints that we receive are with respect to bank charges, and many times they contest the fairness of the charges, but most times they're contesting the lack of transparency in the charges, which is a consumer protection issue. With respect to competition, there is a component also. One interesting thing from a competition standpoint is that bank charges are uniform. And so we must interrogate that and really look at it and say that, does that present a level playing field for competition? Does it promote innovation or not? or should we be moving in the direction where the banks truly compete for customers by providing products, which also includes their charges, that are really attractive and that makes them want to at least get ahead of each other. And so yes, and we are working a lot. We've been working with the central bank, and we're hopeful that soon we would have a far more robust framework. Central bank has also issued certain guidelines with how banks should behave with respect to their charges and ATM transactions. What we're seeing is that there's some effectiveness, but overall compliance is still very poor, and we're developing frameworks that would promote compliance better.
As you know, there are so many complaints about fake products in Nigeria. What is your council doing with the victims of fake products, and also to find a way to get rid of these fake products circulating in our country right now? And
you're right in the sense that adulterated and counterfeit products is quite a big problem. And sometimes you wonder how we can get around it. But what we are doing is we don't set standards, but we enforce standards. We work with the standard setting authorities, for instance, NAFDAC, Standards Organization of Nigeria, to develop approaches to how we can ensure that the products in the market meet applicable standards. And where there are certain small areas where there are no prevailing standards, we're working to initiate standard review to promote standards in those areas. But there are two problems to the counterfeit and adulterated products market. The counterfeit products, for the most part, many times it's an importation thing. We've got to find a way to interdict a lot of these products before they make it into the market. From a consumer protection standpoint, we monitor the markets. It's very difficult to do that, especially the informal sector. You have a regulator of about 200 and something employees that would regulate a 200 million market in 36 states. That's quite a challenge. And so we must devolve methods. One of the newer thoughts we've had, and which we've started a conversation with industry about, is a new business intelligence unit, where we're working with industry to gather intelligence about where products are being adulterated or counterfeited, and so that we can use the entire integrated law enforcement approach to interdicting that. And it's quite a challenge. I must admit that it's quite a challenge, but we're doing everything we can. And one of the things that helps is citizen vigilance. Some of our strongest enforcement initiatives have been because we received credible intelligence. And so when people provide credible intelligence, we're able to clinically go straight to where the problem is and address it very quickly. And so we're opening new channels for receiving intelligence, and some of the type of intelligence we've received are even employee whistleblowing. And many times people go to the market, someone says to you, do you want the original or the fake? And you negotiate based on that. And what should happen in that kind of a situation is that you should report that. And so that we can, go in there. We do some mystery shopping, but how much can we really do with the sheer number of markets across the country? So it has to be a partnership between society and the regulators.
Another question comes, man, and I just want to interrogate more on that informal sector you talked about, because it's quite big, because we've had incidences of some very informal goods. So take, for instance, use of some chemicals to be able to assist the ripening of some fruits and things like that, and a couple of other questions around that area. My question is, how do you use technology, to be able to assist this process real quickly, to be able to get down to the base of all of this in the informal sector? Because like you said, the informal sector is quite mammoth in this country. It's quite big and it's quite out there. And most of the food items we have, especially, are from the informal sector. So take, for instance, people still buy foods like staples like gari in the open market. Who is looking at all of that? If there's too much cyanide in the gari, for instance, in the cassava, who is looking at all of that?
Well, there are multiple regulators in the different spaces. For instance, the analogy that you have created. There's a Ministry of Agriculture component to that. There's a Ministry of Health component to that. There certainly is a NAFDAC component to that. And obviously there is a consumer protection component to that. Sometime earlier on in the year, we put out an advisory with respect to using pesticides to preserve beans, a sniper specifically. And what followed that was interagency and ministerial task force between the multiple different stakeholders, the Ministry of Agriculture, Ministry of Health, NAFDAC, we were there, standards organization, civil society, farmers associations, and all of that. And that's how we have to do this work. Our piece of that would continue to be advocacy, that is to consumer education, while there is also an advocacy for farmers and other people in the production and distribution value chain. And so other departments and ministries are taking all those different roles and engaging the farmers and all of that. But you're right. We've got to move to a point where we can use technology even better. Right now, we put out an advisory only last week about the use of calcium carbide to ripen produce, especially fruits, particularly mangoes. And all we were able to provide was information about how to identify mangoes or plantain or other produce that have been ripened artificially, inappropriately. And we must figure out a way across the board where there are standards for checking and random checks. The problem with the way the market is structured in Nigeria is that as a consumer protection authority, you're dealing with the very back end of everything, in the sense that the retailer themselves are potential victims. And so just imagine if we went in there and confiscated a mangoes inventory of a retail seller, someone whose entire inventory is probably what, 3,000 naira, hoping to sell and make another 1,000 naira. And so if you confiscate that, yes, you're protecting people in some sense, but you're creating another round of victims, because a lot of those things happen before it gets to that point. And it is how we regulators can together make sure we prevent contaminated or unhealthy products from getting into the market. That's really the key, because when you try to do it from a market standpoint, it would only be entirely fair when it's the same supplier who's also retailing. But when you have the nature of our informal market and petty traders and market people, you'd essentially be creating another set of victims if we do not approach this with some level of tact and sensitivity.
Well, I like that you mentioned consumer education. How can we as consumers identify produce like that, produce like mangoes that have been, chemically engineered?
Well, and the key here is not necessarily whether they were genetically engineered or modified. It's really about whether they short-circuited the ripening process so they could get it into the market on time. And so essentially what happens is that these mangoes are harvested while they're relatively green, but because they want to get them into the market immediately, they artificially ripen them. And the way to identify them, for instance, is that they're patches. It's the ripening is not uniform. So you can tell that there are dark patches. Usually for a fruit that's supposed to be soft, this fruit is more often than not really soft. And so for mangoes, mangoes are supposed to be somewhat supple and supposed to be sensitive to depression. And so you would see a mango that seems yellow, but you still have a few dark patches all over it in an inconsistent manner and feels very hard. Then you can suspect that this probably did not ripen naturally. And many times, for those who do not even identify that, if for any reason you bite into that mango, find out that it's probably very hard. If it's an orange, if you cut it open, you'd see that it doesn't seem juicy. It just seems like the pulp is still not fully the balloons in the pop are still strong and the juice is not flowing. So there are few indicators that you use to look at that, and that was in the advisory we put out.
All right. So what are some of the drawbacks or impediments to the enforcement of consumer rights in Nigeria?
Oh, good question. Well, I mean, we're coming from a very dark place with respect to recognizing and showing regard to the rights of consumers. And so because of that, even a great effort only moves us a few inches. So it's going to take some time. I think in the past 2 years, I think as a country we've become more sensitive. But I think the most important thing is consumer education. There is nothing that promotes the enforcement of rights more than people recognizing their rights and demanding those rights. Last year, we ran a campaign across the country. It was a campaign hashtag Demand and Insist. And so it's just let people know their rights and to insist on those rights when they're not respected. And what we found out is that the most robust consumer education effort cannot be the Consumer Protection Authority trying to educate people about their rights. One of the things I found when I arrived at the council was that a large budget item was consumer education. A lot of that was also done by printing a lot of flyers. Now, no matter how many flyers you print, how far can you get to 774 local governments and 200 million people? And worse still is that they printed a large number of flyers which were inadequate anyway. And the distribution channels for even getting those flyers out sometimes took years. And so we've got to recognize that we have to devise other methods of consumer education, which we are. And one of the most important ones we've come up with is to get the companies themselves to take an active role in consumer education. Companies have figured out how to advertise their products to the living rooms and the bedrooms, even in the smallest nooks and crannies of the country. Somehow they get their products there, they get people to love those products, and they get people to know about those products. And that's a lot of research and development that they've done to find the messaging and the right context to do that. And so they must now necessarily make that vehicle available for educating consumers about their rights. For instance, companies should at least inform consumers about redress or mechanisms for remedies when they're dissatisfied. So just imagine if, as part of an advertisement that we see on television or here on radio, in whatever language it comes, that advertisement ends with, if you're dissatisfied with this product, you have a right. And this is how to enforce that right. And reach out to the company itself. This is our enforcement. This is our complaint resolution mechanism. And if you're dissatisfied with us, there's a regulatory authority that you can approach, and this is who they are. So just using that vehicle that they use to push out consumer education is going to be a game changer. And we're working on that, and we're writing regulations that will make it enforceable.
Right. Another question comes to mind, Dr. Babatunde Irukera. That's a question on the synergy between your parastatal and APCON, Advertisers Practitioners Council of Nigeria, because they are the ones that regulate most of these adverts, and most of these brands go through them, because every advert before it airs on every platform goes through APCON. So is there like a synergy that you get to tell APCON about this and say, you know what, the right of the consumer has to be put out there, because that's the way it is done, in every clime. And most of these adverts sometimes are misleading. What's the conversation about that? Because some claims in this advert are plain out lies. Who checks this regulation? And those claims mislead the consumer, and they are false claims in some cases. Apart from APCON checking out this, and I know what APCON would just do is they would check out for superlatives, and that's about it. But what about some claims that APCON might not be able to verify the veracity of those claims? What are you doing as regards that? Then the second question for me will be, what have you done, in feeling the plight and the pinch of consumers with the electricity system in Nigeria, the power sector? Because this is a sector where consumer privileges and what consumers get for the money they pay for the services is next to zero. They hardly, they're entitled, it's supposed to be a right to, to have 24-hour power every day as the service, but they get less than 3 or 4 hours in some areas. And I know you work a lot with the NERC. What has been the handshake as regards this with the NERC to be able to make this, more equitable on the part of consumers? And that will also segue into metering. There's been a back and forth about the metering. Consumers still pay estimated billing. What is Consumer Rights Council doing about all of these three things as we start to wrap it up?
Thank you. So there are two questions there, and that is our relationship with APCON, and then what our role is with respect to electricity distribution. And yes, every stakeholder in the value chain we engage. Actually, we periodically talk with APCON, and you're right. What APCON is looking for is different from what we are looking for. We have a sales promotion regulatory approach where to issue a promotion, you must send it to us. So if you say that 100 BMWs to be won, we would ask you, show us. If you have a field where you've purchased 100 BMWs, we'd like to know. We don't insist that you have that. But you have an understanding with the vehicle dealer. We want to know also that you've allocated 100 BMWs. If you say that it is based on what you see or what you find when you open a crown cap, we want to know what the odds are. So if they're going to win 100 BMWs, how many crown caps is it going to be for every single BMW to be under a crown cap? So we want to know what the odds are. And we also want to know when people win. And so when you're making statements also, we want to know. Some years ago, a company advertised that you could win an aeroplane. And I think it became an issue. Okay, so what was that? What is that? Is that a jet engine or a single engine Piper or a crop duster? And so there were issues around that. And so what our sales promotion regulation seeks to do is to narrow the statements you're going to make, to clarify the validity of the claims, or at least what you intend to do, and to hold you accountable when you don't do that. But I'd say that there's still a lot of promotions out there that are not regulated in the sense that we don't get to know. Somehow, some promotions are launched without us getting to know. And so we're saying technology has to be the best way forward. The newspapers, the magazines, APCON and us, we need to have a single technological platform. And so that nothing goes out without having gone through that. And so we're able to monitor what is out there and know what has not gone through the process or what has gone through the process and is not consistent with the representations that were made in the process. Hopefully that technology and the cooperation across the board would ultimately get us there. With respect to electricity distribution, it's a very complex space, and we're struggling from the back, again, like in most things in consumer protection. I think the real solution would be metering. We have repeatedly said that estimated billing is certainly not a preferred method of billing, but it can be eliminated overnight because of a history. But I think what people are most aggravated about is not the estimated billing in itself. It's the fact that it's just arbitrary. I think people just are upset about being billed arbitrarily. So if an estimated billing seemed consistent with what your consumption is, plus or minus, I think people would still want a meter for the precision. But they won't be aggravated, and they will not feel cheated if the estimation was within acceptable parameters. And so that's what we're saying. We resolve hundreds of complaints every day. But the evidence that that's not working is the fact that for every 100 complaints we resolve, there are thousands that are still arising or that are unresolved. And so there must be a complete industry-wide approach. And everybody must have the political will and the desire, and we must all focus on it. The companies, the regulators, the Ministry of Power, and all. And I think that there's some things, for instance, the new metering regulations using meter asset providers. It's a very ambitious step to rapidly meter, because metering is by far the biggest solution to arbitrary billing.
All right. So one final question for you, sir. You are a legal practitioner with over, 2 decades of experience. And with all these regulations coming into place now with your council, and in terms of competition law, would you say that there are enough competition lawyers in Nigeria to handle some of the cases that may be coming their way?
Well, the one thing I would say is that it's a new area of practice for us in Nigeria. But there's knowledge. There's knowledge. I mean, I regard myself in some sense as someone who's conversant with competition law and practice. And so, I mean, I can't be the only person out there. The firm I worked before I went into government, it's a leading firm, and I know that there are other firms and other lawyers. And the one thing that usually happens with things like this is that people very quickly develop capacity. I know that a lot of people are training right now and gathering the knowledge. And the nature of the legal practice is such that we're not reinventing the wheel. I mean, we're taking, learning from what has happened in other places. And lawyers, if I dare say, are perhaps the fastest learners that I know.
Well, all right. Thank you so much, sir, for joining us on the morning show today. It's been a pleasure having you on the show.